Okay, so security for cost, chapter 8. I can't see that anymore. The court has an unfettered discretion to order a party to provide security for cost. Now, it even kind of sounds weird to my ears saying a party. Technically speaking, I think the rule, which is, I believe, Rule 82, says any party, the court can order any party to provide security for costs, although generally, of course, it's always the plaintiff. Generally, it's always terrible grammar. Generally, it is the plaintiff that is ordered to give security for costs, unless, of course, there's a counterclaim when it might well be the defendant to the original action that is ordered to give security for costs. The court has considerable flexibility as far as making the order is concerned, because it can make it in such amount, on such terms, and in such manner as it sees just. It can even, under Rule 83, order that costs are security for costs are given on an indemnity basis. Yeah, so pretty, wide powers there. In terms of sanctions, the ultimate sanction is if you don't give the security that's been ordered, the court could dismiss the action. So, play by the rules or don't play at all. And that takes me to what for me is the fourth footnote. Well, I suppose it's the fourth footnote for you as well, but I don't know what number it is. And my old friend, the Jeffcoat Spread Trustee Company case. Yeah? I mean, that literally is one of these cases that just keeps giving. Oh, there we are. You can apply at any stage for an order for security of costs, as you can see there, when the defence is filed, and it's therefore inscribed onto the pleading list. You could apply there. You could apply at the case management conference. These are simply points where it might be sensible to make the application. As an example, you can see in 8.3, in Arcus against Balchan, I think Balchan, possibly Balkan Management Limited. This was an application made on the 30th of July 2010. The action had been commenced on the 16th of April 2010, and the defence had been filed on the 14th of May. The judge in the Royal Court described this application for security as arising rather late. It sounds unbelievably swift to me, but hey ho, all in the eye of the beholder. Whereas, by way of contrast, in the case of Jeffcoat, the cause was tabled on the 12th of November 2010. Defences were filed in February 2011, and the application for security for costs was dated 30th of April 2012. So just goes to show. I think that might kind of get us back to. I mean, it might be to do with maybe the complexity of the matter, generally how things are jogging along. It might be a foible of the individual judge, wanted to kind of keep things zipping along, which gets us back to a point that we looked at yesterday in terms of knowing your judge. But I assume that's something that is relatively easy to achieve here, where there aren't that many to get to know. Yeah. Just on the basic facts of the case, yeah. No, I don't remember there being a change of circumstances that led to that. I mean, I'm not saying there wasn't, but I don't remember there being one in that case. All right, so application should be supported by an estimated bill of the recoverable costs. Also, evidence of respondent's supposed lack of funds. You can see as an example there the Ledbetter case. When I say the Ledbetter case, have I given you a citation for that? Yes. So the second footnote for this chapter was Ledbetter or Leadbeater against Landero Limited. Mr. Leadbeater, who was basically the man behind the company, had written letters claiming to be under extreme financial pressure. Although I think actually he'd made a loan to the company, and anyway, let's get away from that. If the respondent contests the making of the order, then he has to set out his evidence for doing so in an affidavit, as it says, typically showing that he does indeed have the resources to meet any costs order that may be made, and therefore the application and the order are redundant. So, court's approach, 8.4, in the Arcus case, suggested that English authorities have been followed by courts in Guernsey, and that's been pretty consistent, although not always the case. So as you can see then, Rule 25 in the Civil Procedure Rules, specifically 25.13.2, although I don't think anybody would ever expect you to type that in an exam. Then security may only be ordered if any one of these conditions is actually met. So plaintiff resident out of the jurisdiction and does not reside in a Brussels contracting state, a state bound by the Lugano Convention, a state bound by the Hague Convention 2005, or a regulation state as defined by the Civil Jurisdiction Justice Act, although of course this is only applying under the Civil Procedure Rules. So, obviously it won't be a regulation state. Well, it'll still be defined by that act, I suppose. Plaintiff is a company or a corporate body, wherever it's incorporated, in Guernsey or outside, reason to believe that we're unable to pay the defendant's cost in order to do so. And again, historically, I think there's quite a tendency judicially to grant security for cost against companies. If the plaintiff has changed his address since the claim was commenced with a view to evading the consequences of the litigation, seems rather odd to me, but anyway, there you go. Plaintiff has failed to give his address or gave an incorrect address, which is really just an example of the previous one. Act as a nominal plaintiff, not as a representative one. Reason to believe he will be unable to pay the costs, or he's taken steps in relation to his assets, perhaps in terms of removing them from the jurisdiction that would make it difficult to enforce the costs order if one were to be made against him. Now, in 8.5, it makes the point that I was just making about the court perhaps treating companies, particularly limited liability companies, differently to individuals in terms of an application for them to provide security for costs. You can see this point I was making just now about the Leadbeater and Landero case. Company's fortunes closely bound up with those of Mr. Leadbeater himself, where its single biggest asset was a loan that had been made to him, more than sufficient to meet the estimated costs of the defendant. Okay, so applicant doesn't need to show the usual civil standard balance of probabilities that the plaintiff company wouldn't be able to pay the costs order, simply if there is reason to believe that they may be unable to pay, the order may be made, and that has been applied also to individual plaintiffs as well, coming back to Jeff Coate. 8.6, court may be prepared to distinguish between a company that's based within the bailiwick or in Guernsey and those outside. So as you can see, you've got an example there of the Mitco case. Significant reason for making an order against the plaintiff company, but not against the defendant on its counterclaims. In other words, they were both asking for security for costs against each other. Was said to be the plaintiff was registered in the BVI, not resident in Guernsey, whereas Devlica was both registered and resident in Guernsey. And it's, I guess, coming back as the paragraph wraps up, to the question of enforceability, effectively. Yeah. So it might not simply be that you're outside of the jurisdiction, but it might be which other jurisdiction you're in. Yeah. So if you were perhaps based in the UK, where enforcement should be fairly straightforward, then that might be a reason not to make an order for security. Okay. So 8.7, it's discretionary. What else do I say? That discretion has to be exercised in what's described as a sensible way. I think that's really all that we need to think about there. Again, coming back to the point about delay being a factor that the court should consider. 8.8, I'm not sure how much use, I mean, it's of practical utility, 8.8 in the practice direction, but I'm not sure that you could ever have an exam question on it. But so Practice Direction 6 of 2009, historically low level interest rates. So obviously any money paid into court security for costs will be put into a bank account, but it's only earning interest at the rate of 0.25, which is, you know, probably as low as it's ever going to get, really. So the Practice Direction said that if the advocate believes that he or she can get a better rate somewhere else or somehow else for themselves, then as long as everybody else agrees, then they can put it there. I mean, why wouldn't you agree? As long as you're happy that it's safe there. As it says, it would be necessary to ensure the court's order reflects that agreement, but then given we saw at the start that it has such wide-ranging powers, then the fact that it can provide for it to be given on such terms and in such manner as the court thinks just would be perfectly adequate to cover that eventuality. Right, okay, other situations. What did I want to say about that? Oh yeah, okay. So 8.8, or as you might think of it, 8.9, because I've done it again. Then, as it says there, the court can attach conditions to an order for security for costs. The request civil, which we haven't got onto, and looks like I think we will get onto actually for our next meeting. Under Rule 80, and appeals to the Court of Appeal. The Court of Appeal has also the power to make an order for security for costs, quotes, in special circumstances. And I think this might be where I was confused in my typing. Remember yesterday when we had that question, I can't remember who it's from now, but somebody said, was there a 1964 Court of Appeal law? And I said there wasn't. It was 1961, but the rules are 1964. Yeah. Anyway, so yeah, the Court of Appeal has the power to make an order requiring security for costs in special circumstances, and it has been said those special circumstances would include the impecuniosity of the appellant, the fact the appellant resides outside the jurisdiction, and where making the appeal is either an abusive process or vexatious. Now, you can see there that residing outside the jurisdiction has subsequently been doubted as a valid reason, and I think it's fair to say that in Jersey, where this used to be a standard reason for court ordering security for costs, it has merely been downgraded to a mere factor to take into account. I think partly, at least, for human rights considerations there. But there's obviously a danger about being barred from access to justice, that type of thing. So, what else? Shelton and Barbie, that's quite a nice little case to have a look at. As you can see, another Court of Appeal case there, making that point about Article 6, so don't need to carry on with that. However, nothing inherently contradictory of human rights in having the jurisdiction to make an order. And you've got this case, Tolstoy Miloslavsky against the United Kingdom, which was actually cited by the Court of Appeal here in the Shelton case. Yeah, Court of Appeal has referred to the situation as a conundrum where the appellant is alleged to be impecunious. So this is just, all of these are just referring to the Court of Appeal's power to order for security, for costs. So you've got to bear in mind, this is a different situation. And that's something that's picked up in 8.10. Yeah, so this is a different situation. The conundrum that they're talking about here is the more difficult it's going to be for the appellant to raise the money, the more obvious the need for an order for security arises, because otherwise they probably won't be able to get their costs back. Yeah? So question whether genuine impecuniosity could probably be regarded as a special circumstance without falling foul of access to justice requirements in Article 6. So, as it says, rather than simply focus on impecuniosity, court should look at the case in the overall justice of the thing. So that's that basically. It is a bit of a fudge. Well, because what else can they say?
No, exactly.
Yeah, yeah. I mean, I guess they're trying to do their best, and they do make the point. In 8.10, they do say, and I think this is significant, because the Court of Appeal is cognizant of the fact that, as they say, the appellant's already had his day in court, and he lost, which is why he's appealing. Yeah, so this matter has already been kind of aired, and so the appeal court will be in a better position to have a view as to the merits of the appeal, whether it's a realistic prospect of success or dead duck, that type of thing. So as I said, security should not be ordered on an appeal unless the appellant's case is weak, possibly with no realistic prospect of success. But as always with security for costs, they try to balance, on the one hand, giving one party access to justice, and on the other hand, and not being kept out because of a lack of resources, and on the other hand, making sure that somebody else isn't put to a lot of expense that they then can't get back again.
Yes, I think judges are saying that we're going to hear this subject matter.
Oh, I think so, yeah.
So in a sense, they've already
well, they're certainly leaning in a particular direction, I would say, definitely. Yeah. I don't think there's anything that would preclude them from hearing the substantive appeal anyway. Yeah. I mean, I thought there was a nice point. This Riki case, it's a New Zealand case, and it was used in the Court of Appeal. So court felt that impecuniosity should not be allowed to secure the advantage of being able to prosecute an appeal that wouldn't be sensibly pursued by a solvent litigant. And that's kind of coming back to that point about, realistic prospect of success type of thing. If it was your money that was kind of at stake here, if you're having to put your money where your mouth is, would you be doing that? Yeah. So a solvent litigant would not proceed with a hopeless appeal, or one where the potential benefits are outweighed by the possible costs. It says, finally, special circumstances of Rule 12.5 should be read narrowly to require truly special circumstances. In other words, that the court should not rush to make an order for security on an appeal. Interesting point coming back to some of the things that we were looking at yesterday. The court left it to others. And this is not obviously the New Zealand court, but the Guernsey court, left it to others to reflect upon the need whether there should be some sort of general merits filter for appeals, or a need for permission, so in other words, leave requirements, something like that, or to be limited to points of law, or an uplift in the £200 figure. Right. Okay. Few chapters to go. Right. It's funny, do you know, when I started to make the notes for this chapter, and I kind of looked at that list there, I thought, oh, it's not too bad then, is it? Because almost all of these we've done in other chapters. Yeah, we've already covered them. The vast majority. I mean, maybe it's not summary judgment because that's chapter 13. But I thought to myself, well, yeah, so this is going to be like the world's shortest chapter, but it's one of the longer chapters, which was a bit depressing last night when I was working on. Anyway, never mind. So, interlocutory applications. You have here a collation of different types of interlocutory applications and cross-references to where in the study guide you can find them. Actually, almost all of them have been addressed elsewhere. At the end of 9.1, it says we need to consider two of these, interpleaders and anti-suit injunctions. Obviously, interpleader we haven't looked at yet, although I've mentioned it once or twice. Anti-suit injunctions we did look at a little bit this morning, but we're going to go back, I'm afraid, and look at them a bit more. Anyway, let's kick off with interpleader then. That's in part 5 of the RCCR. So it's somebody that's basically, you might say, between a rock and a hard place, or on the horns of a dilemma. They perhaps are fairly ambivalent about the situation, but they feel that they might be subject to a pincer movement by competing claims against them. So as you can see there, somebody liable under a debt or money or personality, where he's being sued or he expects that he will be sued, but probably sued by two different parties whose claims are not compatible with each other. Yeah. So as it says there, the applicant anticipates being pulled in two competing directions. That could be anticipates both of those competing directions, or one of them could be an actual one, the other could be a potential. So in other words, I am being sued by somebody, by this plaintiff, but I anticipate that there's another potential plaintiff sitting out there. So they could both be potential, or one of them might be an actual one. So it says you have an illustrative example in the EFG Private Bank case there. And I think there's quite a nice quote from the old White Book. I say old White Book because it's referring to the rules of the Supreme Court, the RSC, which of course were subsumed in what, 98 by the civil procedure rules. But then, yes. Yeah. Well, I was going to say, I mean, you know, certainly Jersey, they're still using the old RSC. So, yeah. All right. So as you can see there, then that I think it's quite a nice little quote. Interpleader is a proceeding by which a person from whom two or more persons claim the same property or debt, and who does not himself claim the property or dispute the debt. So in other words, he's not being assertive about this. Okay. Can protect himself from legal proceedings by calling the two claimants to interplead, that is to say, to claim against one another, so the title to the property or debt may be decided by the court. Now, in a similar situation in Jersey, this would be like a kind of a party cited, that type of thing, maybe like a bank or something like that. So, you know, we've got money in your bank account, we don't want it, but we just want to know who to give it to, that type of thing. All right, so procedure, I think fairly straightforward there. 9.3, note that the affidavit that goes in from the applicant should declare that the applicant says they have no interest in the contested subject matter. They simply wish to cover any charges or costs, any expense they may be put to in this matter. The affidavit should also depose the applicant is not in collusion with anybody that's claiming the subject matter and is willing to pay the sum or transfer the subject matter of the dispute into court or otherwise dispose of it at the court's direction. 9.4 is just a point that I've already made. So you might use interpleader where you're anticipating claims or you're already being the subject of proceedings. If there are current proceedings, then and then the defendant issues a summons for interpleader, then the court can and typically would stay all further proceedings as far as that claim was concerned, because there's no point in dealing with that as a separate matter when you know there's someone else kind of on the horizon or around the corner. Oh yeah, okay. So allocation of roles, which comes up in 9.5 under the heading of powers of the court. As you can see then, when the matter comes back before the court for a hearing, then everybody who is allegedly making or suggested to be making adverse claims on the subject matter should appear before the court. They are, according to the relevant rules, described as claimants, right? The court may order that a claimant actually is to be the defendant in a pending claim, and that might be as well as the person that's applying for the interpleader or on the interpleader summons, or instead of that person. Okay. The court can also order that any issue between the competing claimants is to be set out and then tried. It will direct which of them is to be the claimant. And as I said, I think that they mean plaintiff there. They become so obsessed with using the word claimant, they've kind of slipped into that. And which of them is to be the defendant. So it's interesting in an interpleader that the court has that power to actually determine the precise roles that the various people are going to be playing there. Yeah, okay. So, I mean, yeah, all right, yeah, I'm going to leave that. Yeah. All right, so what else do I need to think about there? Yeah, okay, so default situation then. Oh yeah, I just mentioned very briefly at the end of 9.5, there's a reference there to a summary jurisdiction. That's a possibility. So if everybody consents, or one of them requests it, or it's a dispute over a question of law and there's no factual dispute, then the court can exercise a summary jurisdiction to resolve the matter without having to put it to a trial. But anyway, so return date. What happens if one of the people that it is suggested is claiming an interest in the property or subject matter does not appear? Obviously, there'll be the primary question will be, have they been served? Do they actually know these proceedings are taking place? Assuming that that could be evidence to the court's satisfaction, then it can make an order barring him from pursuing his claim against the person that's applied for interpleader. That will act as a permanent bar as far as that claimant is concerned, but it doesn't have any effect on the rights of the adverse claimants as between themselves. Yeah, so they may still, although they've been barred against the interpleader party, they can still maintain their claim in competition with a fellow claimant. Okay. Oh, all right. Yes. The last point in 9.6. If there's a claimant or a plaintiff already in existence, so there's an action ongoing, and that individual is then served with the interpleader summons. If they don't turn up on the return date, then the court has the power, though I suspect it might not use it first time of asking, but it has the power to actually dismiss the action, which would be hilarious, but as I say, it's fairly draconian, so you wouldn't rush to do that. Yeah, okay. So again, very wide and flexible powers. 9.7. When the court tries an interpleader issue, can give such judgment as it thinks just, make whatever orders that are necessary to resolve all of the questions, and then make any order on costs as it thinks just. And that's also without prejudice to its powers under Rules 36 and 37, either to add someone as a third party or to remove parties from actions. So those powers need to be seen in conjunction. All right. Back to our old friend, the anti-suit injunction. Yeah. All right. So I think I can take this relatively shortly. Ben will be pleased to see there's more listing going on in here, but yeah. But yeah, okay. So essentially, what we've got then with the anti-suit injunction, we've already looked at this, so we can take it swiftly. But as it says there, the typical target for an anti-suit injunction is to restrain proceedings in another jurisdiction. So it's the issue about parallel proceedings, maybe differing outcomes because there are different laws, maybe the evidence is different, all sorts of things like that, and it's just not very compatible with each other. Sometimes, of course, there's a jurisdiction clause that the parties had previously agreed to, which one of them seeks to enforce and therefore force a certain jurisdiction onto the matter. As you can see, it is said that the anti-suit injunction was only recognised recently in Guernsey 2003 in the case of Ashton and Ansell Limited, which we looked at earlier today. 9.10, I think we've already covered all of that. So yeah, 9.11, the approach of the court. As I mentioned this morning, the Winnetka Trading Corporation against Bank Julius Baer is a quite significant case as far as these sorts of injunctions are concerned. And also you have from the Credit Suisse case, which is Credit Suisse and Nemni from 2012, this section from an English case, Highland Crusader against Deutsche Bank. I think I mentioned that this morning. The numbering has gone completely wonky in that quote. So as you can probably tell from the fact it starts with a 0, instead of being 0, 1, 2, 3, 4, 5, it should be 1, 2, 3, 4, 5, 6. Bizarrely, number 8 is actually correct. I don't understand how that's happened. Yours is all right. And then 8. Well, yeah. Well, that's what was in the original judgment. But I mean, well, so why does mine come out as a 0? That is peculiar. Anyway, all right, that's fine. As long as yours starts with a 1, that's good. Okay. So 913, I think that passage from the Winnetka Trading Corporation case we've already looked at this morning, that paragraph 40. Brussels Convention doesn't apply to Guernsey. And we've then got paragraph 41 of that judgment, which is quoting from Standard Bank against Agri-Invest International, which is an English case. But you can see there the Court of Appeal saying would endorse that as representing law in Guernsey. We've then got, for reasons that are, I don't know, nonsense really, a kind of list of other cases that have said the same thing. But the important thing, I guess, is summarised by Mr. Justice Cook in the Trafigura Bahia and Cookme Bank case. So court will grant an injunction where the pursuit of the foreign proceedings is unconscionable. That should be is not in.
So what was that?
Trafigura. It's just yeah. Sorry, it's not. It's a bit hard to set it out because I'm quoting from them quoting from somebody else. There's like quotes within quotes within quotes. But yeah, sorry, Trafigura. Yeah. Oh yeah. So little 2, court will readily grant an injunction to restrain proceedings which are brought in breach of an exclusive jurisdiction clause. What else have we got? Yeah, 3, absent an agreement to the exclusive jurisdiction of the English court, this of course being an English case, that's why that reference is there, or some other special factor, a person has no right not to be sued in a particular forum. Okay? If action is brought in a foreign forum, the question whether or not that is an appropriate forum is a factor in assessing the conduct of the party suing there, for the purpose of considering whether to grant a restraining injunction, restraining in this context being an anti-suit injunction. Yeah, 4, little 4, to grant an injunction, the English court must have a sufficient legitimate interest in the foreign proceedings, meaning that if there's no contractual reason to prevent suit there, like an exclusive jurisdiction clause, there must be proceedings in this country, i.e. the country where the injunction is being sought, which require to be protected. Yes, comity, I did mention that this morning. So little 5, English law, and I know Guernsey law also attaches a high importance to international comity. Perception of the foreign court of an interference in its proceedings, albeit indirect, must therefore be a clear need for protection of the English proceedings if an injunction is to be granted. So clearly, if there are no kind of domestic, if I call it that, no domestic proceedings afoot or very swiftly anticipated, then you're like to be on a sticky wicket as far as getting an anti-suit injunction is concerned. And 6th point then, an injunction should not be granted if its effect would be to deprive the claimant in the foreign action of an advantage in that forum of which it would be unjust to deprive him. So of course, what that's suggesting is that with this type of application for an anti-suit injunction, the court may well require some sort of expert evidence as to foreign law. Yeah, all right, so yes, and also that last point in paragraph 42, presence of a jurisdiction clause is a basis, but not the only basis for granting an anti-suit injunction. And lastly, from Credit Suisse itself, Lieutenant Bailiff pointed out, incumbent on a party that wants an anti-suit injunction to do so promptly before the proceedings, foreign proceedings are too far advanced. I think I did mention that earlier today. Okay, nearly done with chapter 9. So stays, three other things to think about. Stays, striking out, and anti-suit injunctions. I can't believe such a thing exists, but it does. So, 24. Oh, okay, yeah, all right, I see what I've done there. Okay, so 9.14 then. Oh, right, so it's a possibility then, as it says towards the end of 9.14, after a rather woolly prelude, if the foreign plaintiff is unable to obtain an anti-suit injunction in the foreign court, or perhaps is concerned that the Guernsey plaintiff will ignore it, which gets us back to that thought about this being an injunction that's in personam. So, you know, if you're not in the foreign jurisdiction, why do you care what they're saying there? The foreign plaintiff may decide to come to Guernsey and ask the court to stay the domestic litigation, pleading, if there is one, a jurisdiction clause in an agreement. And I've offered you the Crociani case from Jersey as an example there, where their application for a stay failed, them having been subject, in fact, I think initiated proceedings, if memory serves me correctly, in the Royal Court in Jersey. Didn't like the way that the wind was blowing there, decided to take themselves off to Mauritius. Well, why not? It's a lovely part of the world.
Did you,
Yes.
is the Christianity cited in the
I don't think it was. I think I mentioned it just as talking about it, but I don't think it's actually referenced in there. Yeah, there is a reference, but I mean, yeah, but that, you know, that I think is the reference to the Privy Council decision on the stay application. But I mean, there are, you know, gazillions of references. Well, obviously, you know, money is no object. So there you go. Really? Well, I mean, well, anyway, listen, yeah, I mean, it's like an addiction, isn't it, really? It's that Dickens thing, was it Jarndyce and Jarndyce? Yeah. Where the estate has long ago been extinguished, but they're still litigating over it. Yeah. Okay. Right. What else we've got? Oh, strikeout. Yes. So 9.15. So these are all basically alternatives to anti-suit injunctions. So you might appear in the foreign court and just apply to have the proceedings struck out as being vexatious or oppressive. Very, very helpful observation that it might work or it might not. Sorry about that. That's good God. I just realised I foreshadowed Donald Trump there. Yeah. Maybe they did it. Maybe they didn't. Yeah. Oh, God. Well, that's rather, yeah, anyway, I'm not going to dwell on that. It's quite depressing. So as you can see there, that was considered as a potential solution in the Credit Suisse case, but the court there received expert evidence on the subject of Italian law to the effect that there was no procedure under Italian law for the early resolution of the claim by striking it out. The expert evidence went on to indicate if you needed expert evidence on the subject, Italian proceedings are very drawn out, with the case taking perhaps 3 years to get to trial. Then an automatic right to appeal, and those appeals probably taking another 4 years. So, yeah, kind of like a manana approach to case management there. There we go. So it says there, that information was described by the court as not persuasive by itself for granting the anti-suit injunction, but certainly provided further supporting reasons. So, hooray. And then, yes, just when you thought it couldn't get any more kind of Alice in Wonderland, 9.16 heralds the advent of the anti-suit injunction. Yeah. So, this is, yes, an injunction or an application for an injunction to prevent the opponent seeking an anti-suit injunction. Court of Appeal regarded this as quite a rare beast. As it says in that little quote there, phenomenon infrequently encountered in casebook or commentary. Our research has found only 10 instances where the concept was referred to, at least by that name, in electronically available authorities. It was basically someone's Googled it. Yeah. Anyway, so yes, the Court of Appeal went on to consider how useful it would be to make such an order, particularly bearing in mind these things do not bind the other court. However, although that might have sounded like a bit of a negative, it went on to conclude there were 3 potential reasons for making the order. Firstly, that any breach would put the individual in contempt of court, which would exclude them from the proceedings in Guernsey. Secondly, it would be reasonable to proceed on the basis that people respect court orders. I mean, this is an observation made by a court, so what do you expect them to say? Yeah. And thirdly, the reasons underpinning the making of an anti-suit injunction might be sufficient to persuade the foreign court for reasons of comity, not to issue an anti-suit injunction if one were to be sought there. Wow. Yeah. So you never know, I think, is the answer to that. It's worth a shout. And the principles, similar principles to be applied as with the anti-suit injunction. But nice point, they agreed with the commentator, Raphael, in his expert work, The Anti-Suit Injunction, a whole book on anti-suit injunctions. So that's something to look forward to for the Christmas list, perhaps. Yeah. That the particular sensitivity of this type of claim, they mean, of course, sensitivity in challenges between different legal systems, and the inherent risks of escalating conflicts between legal schemes should probably mean that anti-suit injunctions should be granted with particular caution. So don't all form an orderly queue for one. All right, forum non-convenience is another reason for seeking a stay. Again, we have thought about that in various situations. So yeah, 9.18, defendant who doesn't want to come to the submit to the jurisdiction of the Guernsey court should be careful. Simply acknowledge service when the matter is tabled and make it very clear their intention to put in a challenge to the jurisdiction. So if you are putting in pleadings, you should plead an exception declinatoire and just basically leave it at that, I think, along with, as it says, a simple denial of liability. The leading case, which I think someone's already mentioned today, and it wasn't me, the Spiliada case, another English case. Lord Gough, I think, gave the leading judgment on that. So central principle, look for the forum in which the proceedings can most suitably be tried for the interest of all the parties and the ends of justice. Burden of proof rests with the defendant who seeks to stay the Guernsey litigation, because obviously the plaintiff chose to initiate the proceedings here. Need to show two things then, really. First, that Guernsey is not the forum convenience, and secondly, to point to another identified court, which the defendant then says is the place where the matter can most suitably be tried. So it's not simply a negative, there has to be a positive there as well. Right, okay. And then, excuse me, in the next 3 paragraphs, you've got just a couple of example cases. So Winnetka, I've already said that's a nice, interesting case to have a look at, very useful. And then in 921 and 922, I've basically given you, I think, all of the material points in the Healthspan and Healthy Direct case. And that's one where there was potential competition between proceedings in Guernsey and proceedings in England. So, yeah, I think it's all pretty self-explanatory in there. So we will leave that. As far as making interlocutory applications is concerned, as it says, that's already been largely covered in Chapter 5. The jurisdiction comes from the 1987 Law Reform Miscellaneous Provisions, and also Rule 81 tells you the steps to take. And as it says there, it does say, save as expressly provided by the rules, and since the rules on interpleader do actually set up a slightly different process, then obviously you have to apply or comply with those. So application to the interlocutory court, Fridays at 10, I think we did note that yesterday. Practice Direction 1 of 2008. Yeah, okay, so affidavit evidence. This is 924. Very complicated. Rule 88 addresses affidavits. The affidavit is to be made depending on the geographical location where you decide to make your affidavit. You can vary who it should be made in front of. then for somebody to have been so incredibly specific for the bailiwick, then just kind of abdicates all responsibility as soon as you move outside. So if it's made outside the bailiwick, then we don't care who does it, as long as that person is someone who's empowered to administer oaths in that location, or in accordance with the rules that govern the administration of oaths there for judicial or other legal purposes. So there you go. And if the deponent is a serving member of the armed forces of the Crown, then you can depose your affidavit before an officer, commissioned officer in any of the armed forces, not holding a commission in the same branch of the armed forces as the serving member is, just any of them. So it's bizarrely specific within the bailiwick, and then just kind of throws everything up in the air as soon as you step outside. Lots of technical points in 925, which are practically important but very boring. So not going to say much about those, if anything. And then finally, ex parte applications is the last thing in chapter 9. And what can we say about that? Well, we can say that they should be the exception rather than the norm, because it's not really complying with natural justice, which would be to hear both sides. And if you're applying without notice to somebody, then the likelihood is they won't be there, so you can't hear both sides. So they should be the exception rather than the norm. What is it that would make them justifiably exceptional? We can see there, typically, of course, there's some urgency to the matter, so we just don't have the time to give them proper notice, or it's imperative, like with the freezing order, for example, imperative the respondent isn't able to frustrate the relief that you're seeking as a result of being put on notice, right? And the other thing, of course, which we all know about, is where you're making without notice application, you're under an obligation to make full and frank disclosure. So I think that's that. Yeah, sure. I mean, time is our friend at the moment, so yeah. So what have we got? 1, 2, 3 pages. I don't know. Okay, chapter 10 then, payments into court and offers to settle. So both of these are dealt with in Rule 62 of the RCCR, and they may save the, speed things up in terms of resolution. So get rid of delay and save the cost of the trial. So payment into court is, of course, made by defendant. Offer to settle can be made by either plaintiff or defendant. And the offer to settle may be in whole or part satisfaction of the claim, as may be the payment into court. So either resolve the whole thing, or to resolve simply a part of it or one particular issue within it. So as far as payment in is concerned, what do we need to know about that? Yes, notify the other parties in writing. This is all under Rule 62(1)(a). Notify the other parties in writing of your payment in. Lodge your payment with the GREF. If the payee wishes to accept, then they have to give written notice to the payer, and they will then lodge their notice of acceptance with the GREF. Proceedings will thereafter be stayed. The other point, I guess, is in terms of costs there on payments in. You've got this citation by the ordinary court in Buckley and Ronay, citing from the Master of the Rolls in the English case of Roach. Judge must look closely at the facts of this particular case before him and ask, who, as a matter of substance and reality, has won? Has the plaintiff won anything of value which he could not have won without fighting the action through to a finish? Has the defendant substantially denied the plaintiff the prize which the plaintiff fought the action in order to win? As far as offers to settle are concerned, it says any party can make an offer to settle, and that can be for everything or simply a part of the matter. Same proceeding, basically. So written offer, notified to the others, and the copy of the offer to settle is lodged with the GREF. And if it only covers a part of the claim, then it has to specify which part it's covering, and be clear whether it's making allowance for any counterclaim. Does it include an element for interest? How's that being calculated, if so? And whether it includes costs. So all of those things have to be dealt with clearly on this offer to settle. Now, I should emphasize again, this is an offer to settle under Rule 62, okay? As distinct from the Calderbank letter that you can see at the end of this chapter. So again, perhaps because of those points about having to be specific about what it relates to, does it cover the counterclaim, is it interest, is it cost, etc. 10.7 points out that you have 14 days for the offeree to ask for clarification of this. In particular, it may not be clear whether it's an offer under Rule 62 or not. So if that is either not complied with, that request isn't complied with, or it is but not to the satisfaction of the offeree, then they can take it to the court to ask for an order for requested clarification. Under 10.8, an offer to settle can be withdrawn, but only by getting everybody else to consent, all the offerees to consent to that. An offeree who wants to accept the offer to settle gives written notice, has to be unconditional acceptance, and lodge a copy with the gref. Again, thereafter, the proceedings or the part that the offer related to is stayed. Cost point comes up under 10.9 again. So the fact of an offer to settle not to be disclosed to the court until all issues around liability and quantum have been resolved, quite typical. And then once the court moves on finally to consider costs, it will look at the circumstances of the offer to settle, when it was made, whether it was accepted, and when. Yeah.
Indemnity costs aren't, it's not automatic in there, is it?
I don't think so, no. No.
So it's just, so this takes into account when it was made, et cetera. That's just,
You just follow the law.
you just follow the normal rules.
Yeah.
Can I check if you just went up with withdrawal? I thought
Mhm.
actually you had to consent for
Sorry,
or the offerees.
yeah, consent of all the offerees, yeah.
What do you mean every party? As if
All right, no, I think it's only the offerees. I'll have a look.
It says every other party, which is defined as the offeree.
Well, 62.7, no payment into court or offer to settle may be withdrawn except with the consent of all parties to the action in respect of whose claim the payment into court was made or to whom the offer to settle was made. So although it's yeah, yeah, yeah.
So does that imply?
I think there is an implication to that effect, yeah.
But the effect of that is that you practically in the same way as this, you can't make it permanent, can't say, if you do not accept within.
Oh no,
days,
no,
it will be
no.
withdrawn.
But that's the difference between that and the Calderbank. Yeah, yeah.
So if you make it part of it,
Hmm.
unless the person who's consenting to the offer to,
Yes. You're stuck with it.
you're stuck with it.
Yes. Yes, yes.
Because you do see people make
No, they can't. I don't think they can be. That's one of the significant differences between the Rule 62 and the Calderbank. Yeah. Right. Yes. Right, yes, yes.
I'm also confused about.
Mm-hmm.
Talks about disclosing.
Yeah.
Where Rule 64 from
Well, disclosing it to the judge, court as judge, or judge as court. Yeah. Yeah. I mean, obviously, the court, in the broad sense, is aware of it because, as you say, it's been lodged with the graph, but no, mustn't be disclosed to the judge in the proceedings. Sorry. Yes. Let me. Yeah. Sorry. My shorthand. Okay, not very short, but anyway. All right. So yeah. Lastly, then, Calder banks. So simply a written offer to settle without prejudices to costs. And as it says there, ordinary court has said that such an offer does not have the full consequences of either a payment into court or an offer to settle, which are pursuant to Rule 62. So yeah, an important feature of litigation. When exercising discretion on costs, consider what weight to be attributed. And unlike the Rule 62 stuff, a Calder bank offer may be withdrawn at any time and may be only made available for a certain period of time. And you can see for example, there in that footnote, Buckley and Rones offer notified to the plaintiff on the 28th of November for due to expire on the 1st of December. So that is a bit of gamesmanship going on, or brinkmanship going on there. Interestingly, as you can see, Buckley, also in Buckley and Rones, the defendant, as well as sending the Calder bank letter, which offered 58,500, the day before had made a payment into court of 43.5. So what, £15,000 less. So I still haven't worked out whether that's a stroke of genius or a sign of rampant confusion going on there.
I can't think there's any attraction of making it under 62
Mm.
as in the Calder bank, because there's no because the rules under which you make it. So if you're in England, you make a part of
Mm.
If you can still make a Calder bank, then you're under the court's discretion on costs.
Mm.
In Guernsey, if you make a 62 offer and successful, you're still under the
Yeah,
regime of
yeah.
the court's discretion. Yeah, and if you make it under
It's you better stay for indemnity costs. But there's
Mm. No.
I disagree with that.
Uh,
Which is we have some of the debate.
yeah. That is interesting, actually. Yeah.
What your views on it, because that's not the rule set.
Yeah.
But it's never, there's no kind of testing on it, because often these
Just go by the by. Yeah.
So you could have a situation where you make a Rule 62 offer and you can't withdraw it because, or you
Well, because nobody consents to
don't
that.
consent
Yeah.
to it, and that offer is still valid and we can which strictly is part of
But then accept it, yeah.
There's arguments about when the costs
Yes.
should be paid upfront.
Yeah.
There's no procedure for that.
Well,
It's all theoretical.
yeah. Well, yeah, it's back on case law, isn't it? Yeah, precedent. Yeah.
You
Isn't
don't
it?
probably know
Yeah.
what it needs to do.
Yes. So a situation where getting a judge in would be useful. Really. Yeah.
But it will all be those will all be decisions that we will make on taxation or taxation.
Mm. Yeah.
Where
Yeah.
one.
Okay. All right. Well, going out with a whimper, not a bang. Should we leave it there? That's pretty much it. Yeah. Okay. Good. No, thank you. And I'll see you in 2 weeks. Yeah, it's the 8th and 9th, isn't it? Yeah.
Yeah. And you're working
On the 15th. Yeah. And Kate. Yeah.
2 days on that. It's like you do-
What, 15th, 16th?
Yeah.
Yeah, because the 15th is ethics, and then the 16th is meant to be the money laundering with Kate Raby. Yeah. No, someone was saying yesterday that it said TBC. I mean, that's not my understanding. My understanding is that we're starting just the same timings that we've done this weekend.
Are you getting the same lights?
Yeah,
That we choose five.
yeah, yeah.
And
Yeah.
do you guys notice another one that says if it's criminal or